Hi, I'm Jim Ferrell, and the name of this video is State of Probate Address 2012. Yes, this is about probate and one of the biggest businesses in the United States, and as far as that goes, the whole world. And it's growing bigger and bigger every day. Some big cities have as much as 10,000 open probate cases alone. It varies greatly, but they all have a lot almost all over the world. The reason being is that every year you have babies born and you have people dying. However, the largest part of the population right now are the baby boomers, and these are in their retirement years and are unfortunately dying. So therefore the courts are literally jammed with it. The biggest reason they're jammed is because less than 10% of the people have a trust set up by an attorney that avoids probate. As far as that goes, well over half the population doesn't even have a will. And if they do have one, it's probably way out of date and it's almost worthless anyway. Wills normally won't keep you out of probate court, but they'll certainly speed along the process. The reason being is that when the process starts, you have to fill out the paperwork. Normally in all states you need an attorney, and this attorney will fill it out for you. And it's right on most county websites what you need to do. However, every time you go in the court, it's usually postponed another 2 months and another 2 months and another 2 months. And if there's real estate involved, you're paying taxes and mortgages. I believe in Florida less than half of all probates have a mortgage on them anyway. But you're paying utilities and all these fees, attorney fees and court fees that just keep adding up. And it really doesn't have to be that way. As most probates take 13 months to do, some take 3 years. It shouldn't, again, only take months. The reason being, if you filled out all that paperwork in the beginning, it would be done. Such as, for a certified probate liquidator, these are not necessarily attorneys. That's what we are. We are not attorneys. We are liquidators. So we fill out the paperwork, such as the inventory. You have to know the assets. For instance, how much is the estate worth? What are the antiques, trains, boats, planes, all worth, and jewelry in the estate? As far as that goes, the value of the real estate. All these things need to be known. We also get the creditors together if they need to be negotiated with, which is it's highly negotiable, especially credit cards from the deceased, and also any heirs, so that the siblings will not fight over silly little things. One of the biggest questions we get from siblings is that Mom wanted me to have it. Well, maybe she didn't. Well, if she didn't put it in writing, it's probably not going to fly very much in court, especially if you want a $5,000 ring and all of the other siblings get a $500 ring. That usually doesn't fly too good with the judges. So Mom had better put it in writing in a will if that's the way she wanted it. Okay? So this is how we liquidate the process, by doing all the paperwork in the beginning, getting the values, working with everybody so everybody knows what's going on right from the start of the entire process. Then, when something called a 90 days notice to creditors is done. Now, this is a required ad that needs to be in the papers. Now, it can vary from state to state. We'll just use 90 days as an example. That's what it is in most places, but it could vary a little bit. Therefore, these ads are required by law in a paper. Now, this does not mean it's in a major newspaper. After all, do you really want to advertise to the world if the estate owes anybody any money? So therefore, here's a little tip for you. Save yourself a bunch of money. Instead of having the attorney run it in a major newspaper, and let's say it's cost $1,000 or more, run it in a small paper that might only cost a couple $100. So, therefore, that's a big tip right there that a lot of people miss. After all, you don't need to pay for your attorney's advertising. Right? Right.